Good evening, you're watching News Today at 9 p.m. I'm Preeti Choudhry. Let me quickly take you through our big talking points this evening. Well, the top one came in from the top court of the country. No bail for Khalid and Sharjeel Imam. Flaws in criminal justice system exposed. We have with us former AG Mukul Rohatgi, exclusive. And on the other side, which is at 9:30 p.m., we're going to get you what is Trump's plan for Venezuela. All of that coming up. Justice and liberty, viewers, are in stark contrast this evening. As under trials remain behind bars, a convicted God-man, self-styled God-man at that, walks out yet again. The top court of the country has denied bail to Khalid and Sharjeel Imam in the Delhi riots conspiracy case, ruling that this is not the stage to grant them relief. The court, in its verdict, said the remedy for delay in trial in UAPA cases is not automatic bail, but expedition of trial. But as Khalid and Imam continue in jail, the contrast sharpens elsewhere. You have the self-styled godman, Dera Satya Sauda chief Gurmeet Singh, convicted in a double rape case for 20 years and facing murder charges, has been granted parole for the 15th time since 2017, walking out of prison once again, this time for a cumulative 40 days. Very different cases, very, very different laws. Many are saying you're comparing apples to oranges. But are we really comparing apples to oranges? Because at one end, you have under trials. The trial has not even begun in the case of Sharjeel Imam and Khalid. The charges haven't been framed. They've been in jail for 5 years and they've been denied bail. On the other hand, you have a self-styled God-man convicted for 2 rape cases, serving 20 years in jail, facing murder charges, walk out 15 times in the last 4 years. This time around, for 40 days. The last parole was another 40 days, which he was out in August 2025. Different cases, really, right? Different laws, but quite the same. Tonight, one question dominates the debate: how equal does justice really look? We first take a sharp look at the Supreme Court's verdict denying Khalid and Sharjeel Imam bail and the reasons cited by the learned court. Here's a report. My colleague Shrishti Oja filed this.
Big setback for 2020 Delhi riots accused Khalid and Sharjeel Imam. The Supreme Court on Monday denied bail to the 2 accused, who have already spent more than 5 years in jail, even as the trial is yet to start. The court granted conditional bail to Gulfiza Fatima, Mir and Haider, Shifa-ur-Rahman, Mohammad Salim Khan, and Shadab Ahmed. The 2-judge bench of Justice Arvind Kumar and Justice N.V. Anjaria ruled the Khalid and Sharjeel Imam stand on qualitatively different footing when compared to the other accused. The court said prosecution material discloses prima facie allegations against Khalid and Imam to the extent of planning and organization. The judges ruled that they cannot ignore prosecution material merely because incarceration is prolonged. The court said that at this stage of proceedings, bail for them is not justified. Khalid and Imam can seek bail after 1 year or after examination of protected witnesses is over, whichever comes earlier. The court in its ruling laid down conditions for bail under the Anti-Terror Law, Unlawful Activities Prevention Act, or the UAPA. The judges said in cases involving national security, delay can't operate as a trump card but triggers judicial scrutiny. The court ruled that assessment of liberty of a person is different when cases are about threatening foundation of the state. In deciding bail, the court needs to examine if prosecution material prima facie discloses offences alleged. If material shows unlawful activity as defined under the UAPA, where statutory threshold is crossed by the accused.
This is a landmark judgment. This judgment has paved way and given clarity in how the UAPA Act has to be applied in various matters where there are accused who are languishing in jail for a considerable period of time.
The Supreme Court verdict has sparked political storm.
शर्जील इमाम और उमर खालिद की जमानत की अर्जी को खारिज किया गया। हम माननीय कोर्ट का स्वागत करते हैं और ऐसे लोग जिन्होंने दिल्ली को दंगों की आग में धकेला, उन्हें कड़ी से कड़ी सजा मिलनी चाहिए।
अगर कोई कानून तोड़ा है तो आप उन पर मुकदमा चलाइए, उनको अपनी बात रखने का मौका दीजिए। उसके बाद कोर्ट जो भी सजा सुनाएगा उसको हम सब स्वीकार कर लेंगे। जबकि आप राम रहीम को और सेंगर को, जो कन्विक्टेड रेपिस्ट थे, उनको आप दे सकते।
It has been more than 5 years since the Delhi riots, but the trial in the case is yet to begin. The Supreme Court verdict means Umar, Khalid and Sharjeel Imam could be looking at 1 more year in jail before a bail plea can be filed if the trial is not expedited.
The court's opinion is very clear. Personal liberty matters, but not at the cost of national security. So basically, 5 of the accused will walk free on bail with conditions, but these 2 will continue to remain behind bars. In India's legal theatre, though, the story isn't over yet. It's only entering its next act. The focus now shifts back to the trial courts, and the public opinion, as usual, remains sharply divided. With camera person Kunj Bihari from New Delhi, this is Srishti Ojha for India Today.
All right, joining me now is Mr. Mukul Rohatgi, Senior Advocate, Supreme Court, former Attorney General of India. Appreciate you taking the time out and joining us, Mr. Rohatgi. You've called the judgment today a balanced one. Why do you say that?
So, madam, let's first understand that a judgment on bail is not a final verdict on the accusation. That final verdict will render conviction or acquittal. So this is a judgment which only looks at a prima facie view of the nature of allegations, the nature of the defense, the nature of time taken, the nature of the material, and the complicity on a prima facie basis, and then take a call whether somebody should be on bail pending trial or not. That's the first thing. So please don't read the judgment as if it's a final Bible on the case. That is not so. Why I called it balanced was, after having the benefit of reading this judgment an hour ago, I find that 5 out of 7, I think, have already got bail.
Correct.
The 2 who haven't got bail, their role has been found to be more central and more complicit, prima facie, on the materials available as per instigating these riots in which 50 or more people lost their lives, that it was a deliberate scheming, etc., etc. Now, I have no reason to doubt what the court has said. The court has discussed the issue of delay which has happened till today and come to a conclusion that delay by itself will not automatically be a trump card for bail. But I have one issue with the judgment which I want to raise. All in all, you can say it is balanced, but one issue I want to raise, and that is this, that the court has not considered what is the prognosis for the future. Assume that 5 years have gone by and the trial has not started. That itself is a big blot on the judicial system and the prosecution, the benefit of which should go to the accused. That's the first thing, which I think there is some flaw in the judgment. But the judgment does not notice as to what is, when will there be light at the end of the tunnel. I find that several charge sheets have been filed. Charges are yet to be framed or are being framed. The trial is yet to commence, and there are about 800 odd witnesses. So if the prognosis is that the trial is not likely to finish in the near future, that is also an entitlement to bail, and that the judgment has not considered.
And that's
Lastly,
right. Make your point, sir.
Lastly, I would say that it leans in favor of reasonableness because the last portion of the judgment gives another chance to these 2 persons that if there is no proper progress, they can apply for bail afresh after 1 year. So it's not absolutely a dead end for them. There is one more a chance after 1 year. I wish it was 6 months instead of 1 year, but that is still another chance. And I well nigh think that this trial is no way going to be any early completion, and
Exactly.
these chaps will therefore get bail in the next round after 1 year. They'll have
So,
to suffer one more year.
but, but
Yeah, yes.
But Mr. Rohatgi, that's where the criticism comes in on why many are calling this judgment flawed, which is why, what will this 1 year bring, which 5 years of incarceration hasn't been investigated yet, and the sheer fact that 5 years, which you also yourself admitted, in jail, the trial is yet to begin, the charges haven't been framed yet, somewhere down the line erodes and undermines the presumption of innocence, which is the founding principle of criminal justice in this country.
Except that, you are right, except that two things. One, when you are dealing with cases of sedition and cases of unlawful activities, which are crimes against the nation, against the fabric of the nation, the absolutely pure principle of bail and not jail will to some extent get diluted. On the other channel, I gave an example. Look at PMLA. The maximum sentence for money laundering is 7 years. But there, under the law, Parliament has put fetters on the court granting bail even in a 7-year sentence, unless the court finds, at least prima facie, that the person is innocent. I don't know how a court can
Mr.
find a...
Rohatgi, you give the example of the PMLA. Now, let me come back with the example of PMLA only, sir. You've had the top court of the country which granted bail where PMLA was concerned, and you can draw a parallel here with the UAPA under which these two boys have been charged under. And you had Arvind Kejriwal and Manish Sisodia who were granted bail. A precedence of sort was set by the Supreme Court, which today many cases are argued in court on the basis of that precedence. And
No,
here...
you are right. Every day I am arguing for individuals in favor of bail, but I would only say, I was giving that example to say that even in a 7-year sentence case, the maximum sentence, the legislature has put some fetters on the court granting bail. I am contrasting this with the case of UAPA and sedition under 124A, where the punishment can even be death. Therefore, the same yardstick may or may not apply. But as I said, I would have been happier if the court had said we give 6 more months to the prosecution to complete the trial, remove the number of 800 witnesses and bring it down to say 50 and finish with this case. 6 more months could have been...
The argument is, what will those 6 months or what the court, the learned bench has decided, a year, actually prove? What will one gain from that?
I will tell you. See, one lives on hope. Now, with a stricture like this, that you are getting 1 more year, if the prosecution pulls up its socks and examines all the relevant prime witnesses, if not 800, in every case, prime witnesses are 10 or 15 or 20. If they examine all 10, 15 and 20, they can certainly examine in 6 or months. Now, if those witnesses and their evidence points towards no complicity, then straight away after 6 months, based on that material, they will be entitled to bail. But
sir, it's been 5 years. If the investigation hasn't been completed yet, is again something which the defense had argued in court.
So, madam, as I said, it's not always an inflexible rule of delay in trial. Generally, this rule will work in favor of bail. But in this case, I also found that some amount of blame was put on the accused for the delay in the last couple of years. So kind of delay was apportioned between the accused and the prosecution. And it was not a case of innocent man sitting in jail and the delay just being occasioned by the prosecution. There are some passages to that effect also. So now look, 5 of them out of 7 have got bail. 2 remain. For them, there is another window. after 1 year. According to me, it should have been 6 months, if at all. And then, they have another chance to show that if no other material comes forward in the form of independent witnesses, then they will get it. I mean, you look at it in a very broad
Okay.
fashion.
But Mr. Rohatgi, let me ask you one final question, because,
Yes.
we are speaking about 5 years of incarceration, we are speaking about no trial, we are speaking about no charges fixed, yet jail and denial of bail. Now, I'll take you back, sir, to August 13th, where, the bench of Justice Okha and Justice George Massey of the Supreme Court said the legal principle, bail is rule, jail is exception, is applicable to offences under special statutes like even UAPA. And they gave somebody bail who was under the anti-terror, charged under the anti-terror law, stating that denial of bail is the denial and a violation of fundamental rights.
So, madam, I agree with you, but every statement of the law is not to be read in abstract. The law is applied to facts. Now, I don't know what the facts are of the case that you are talking about. That's an abstract statement that even in UAPA, this is the rule. But I mean, if you look at the facts, if they are correct, I don't know whether they're correct or not, but if you look at the facts, if people have instigated a riot in which 54 people have died, that can't be, just applied on an abstract principle that bail must be granted in UAPA. You have to, the flesh and blood of a case is facts. It is to those facts that you apply a legal principle. There is no legal principle in vacuum. That's very important, madam.
Okay.
So reading one line from here or one line from
Fair
there,
point.
not going to help.
Okay, because the PMLA, the UAPA is a draconian, archaic law, is something that is being debated far and wide, sir, which is in the court as well. Now, where the UAPA is concerned, and with what you speak of, will this now set a precedent in other cases like, and we'll draw parallels here, which you yourself drew of the PMLA, because once you had an Arvind Kejriwal and an Manish Sisodia who got bail from the Supreme Court under PMLA, it made it very simple for others as well, charged under PMLA, to get bail because precedence was sought. Do you think this will now also set precedents where people who have been charged under UAPA will find it that much more difficult?
I don't think so that at all, madam. As far as bails are concerned, there is no great precedential value. As I told you, they are not final judgments. They are judgments on the facts of a case, whether to grant liberty or not. So there is no great precedential value of these bails. You have to apply general principles to the facts of every case. So it's not as if that everything tomorrow will become difficult or everything tomorrow will become easy because of Sisodia. I can give you any number of examples that even with Sisodia's law being there or judgments being there, people have been denied bail by the Supreme Court even after 1 year or 1.5 years. In case of PMLA, where 7 years is the maximum sentence. I have done cases where the allegation is that somebody has cheated banks of 5,000 crores or 10,000 crores. That also affects the mind of a judge. And they are not getting bail.
All right, sir. So net, Mr. Rohatgi, you say this was a balanced judgment, but two things where you say that it's been 5 years, it's a blot on the judiciary, that trial hasn't begun. That's one point that you make. And the second point that you make is that you wish that the 1 year window was brought down to at least a 6-month window.
Yes, yes.
Those are the two points?
That would have made it, passable. It would have made it...
more balanced.
Yes, absolutely.
All right, sir.
Thank you.
Thank you, Mr. Rohatgi, for joining us. Thank you. All right, so before our face-off at 9 p.m., the big questions that we pose: jail or not bail, the principle for a draconian law like UAPA. Prolonged trial means prolonged jail. Well, that is what an understanding came off the reading of the order today by the top court of the country and the bench. The other question that we pose: UAPA prone to misuse by the state, criminal justice system flawed. Let's take all these questions to our panelists this evening. Joining me, Satya Jain, Additional Solicitor General of India, Colin Gonsalves, Senior Advocate. I'd like to begin with Mr. Satya Jain. Mr. Satya Jain, how do you, somewhere down the line, reconcile the principle of Article 21 that stands for freedom and liberty with what the court said today? And to quote the order, over 5 years without incarceration, prolonged pretrial detention should not equate to punishment. How do you reconcile both, especially at a time where trials move at glacial pace, delayed systematically, where charges haven't been framed yet? How do you reconcile that?
To my mind, it's a very balanced judgment. It has taken into consideration all the facts and evidence of the case on file, as well as the law which is prevalent at the moment. You see, understand the principle of criminal law. Any person who is arrested by any agency, prosecuting agency, the moment he is produced before the court, then it is for the courts to decide whether to grant him bail or not to grant him bail. Any accused
I'm
may
sorry
be
to
of a
interrupt, and
special.
I'll allow you to continue, because at least with what we've learned, and you're way more learned than most of us, because we have not a deeper understanding of the law, the principle and the tenet of criminal justice lies on the fact of presumption of innocence. Innocent until proven guilty.
I'm replying to your question. Basically, now this issue, whether he is entitled for bail or not, is not decided by the government, not decided by the prosecuting agency. After the arrest within 24 hours, the accused is in the custody of the courts. So if you have to apply for bail, maybe a normal law, maybe a special law, maybe UPPA, maybe PMLA, whatever it is. In the present case, both these people, all the people applied for bail. The trial court dismissed their bail application. High Court also dismissed their bail application. And today the Supreme Court, out of 7, has granted bail to 5 and has declined bail only to 2. Why are we forgetting that the same bench, which according to some people did not apply the principle of no bail, no jail, etc., they have already granted bail to 5. And when they have granted bail to 5, declined bail to these 2 persons, the judgment, which is 142 pages judgment, has dealt with the whole issue in detail. The court has found that these are the persons who are indicate a central and directive role.
Mr. Jain, allow me to come in again. Allow me to come in again, because you talk of granting bail to 5 and not granting bail to 2.
Yes.
But the fact is, sir, that today one might say, and the court said, that these two are of different footing and their nature of participation in the crime was different. But for the last 5 years, they were pulled in with the 7, where they were denied bail together. They were put together as a part of a larger criminal conspiracy. And suddenly you define their role differently this time.
Madam, please, I will not like to comment on your comments as a lawyer, otherwise I can say many things. See, when the charge sheet is filed, there are hundreds accused in certain cases, 50, 20, 10. Now the role of each and every is different. Ultimately, it is the court which examines what is the role of each and every person. For example, you murder a man, somebody fired at it, another helped him, another got something. The role of each and every person in any criminal case is different. And ultimately, when the screening takes place, it is the highest court of the country which has examined the entire evidence and has come to the conclusion that other 5 may be given the benefit of bail.
With what you say, the hierarchy of participation, something which the court also used, you don't find it in conflict with Article 14, equality before law?
Article 21 doesn't mean that
Article 14, which is violation of Article 14, sir, equality before law.
That principle, if Article 21 is applied in that way, then everybody will be released on bail, whatever the offense. No, Article 21 is subject to the regulation by the laws of the land.
UAPA, so I'm talking about Article 14, like I said, you're way more learned. I'm talking about Article 14, equality before law.
Article 14 is
with
not
what you call the hierarchy of participation.
Article 14 is not available in criminal law. It's a civil matter in the matter of services and all that. Criminal law doesn't recognize Article 14. Your role can be different. 2 persons committing offense, one may be the major role, another may be the side role. The court decide accordingly. Let's be very clear about it.
All right, so I want to bring in
of Article 14. So far as the delay party is concerned, Supreme Court has found that delay is not attributable only to the prosecuting agency. Delay is attributable to them also. They have also been getting dates after dates. So it's not that delay is only
fair point. But Mr. Satyapal Jain, the fact is that the key witnesses haven't even been questioned yet, that charges haven't been fixed yet. Do you not think that this is a blot on the judiciary, which we'll come back to? Allow me to bring in Colin Gonsalves, Senior Advocate, Supreme Court. Mr. Gonsalves, the court also said, and so did the prosecution, reiterate the fact that a large part of how slow things have processed is because the accused constantly kept cancelling dates, and the onus lies on the accused why the trial is so slow. Sir, you're on mute. You're still on mute, sir.
No, not
Go
true
ahead.
at all. And let's not take that, let's not allow such an excuse to come on air again and again. The conduct of a trial lies in the hands of the judge. It lies in the hands of the public prosecutor. The accused here did not delay the trial, but even an accused who delays the trial can be treated very tough by the court and the public prosecutor, and not a single day's delay can be allowed. You have control of the trial. Therefore, do your trial. And look at the travesty of justice here. 800 witnesses, 5 years pass, not one witness examined. Is it not deliberate inaction on behalf of the state? Passing time, wasting time, to see that ultimately, he will stay 10 years in jail and still his trial will be at some initial level. It reminds me of the emergency. Madam, it reminds me of the emergency. And it reminds me of the terror of the emergency, Indira Gandhi's emergency, where people were locked up and, lost sight of. It reminds me of the emergency because no one had the courage. No court in the country had the courage to stand up to Indira Gandhi. God knows why, but they could not stand. These are shades of an emergency. And the people who are in jail today are like all those who were in jail in Indira Gandhi's time. They suffered in jail. Many of them in the opposition in government today. They suffered in jail. And when they came out, they were treated as if they were heroes by the Indian public. I know Khalid. I know these people. I've seen their work. Never thrown a bomb, never done violent actions, never fired a gun, never, ever a single act of violence not alleged against them in the charge sheet. No violence alleged. Some speech that he gave. And he started the riots. I handled today the Delhi riots case in the High Court. The case that I filed is for an FIR to be registered against those who started the Delhi riots. And you know who did it? Anurag Thakur, Parvesh Verma, Kapil Mishra, who stood on a stage and said, and I gave the videos to the court, Desh ke gaddaro ko goli maro salu ko. And after giving those very insightful slogans, walk through the streets of Delhi repeating the slogan. That is how the Delhi riots began. Okay. I've got it on video. I filed it in the court. Supreme Court directed the High Court to expedite this matter 3 times. 5 years have passed. The High Court has not even begun the matter. Reluctance to start a matter because their own leaders will be found out to be the persons who started the riot.
Mr. Gonsalves, the question I'd like to ask you is, do you fault the draconian archaic law like the UAPA, or do you think the reading of the law was flawed in this judgment today, which denied bail to both Umar and Sharjeel?
See, the law is archaic, not archaic. The law is draconian, but I don't want to make that point. I don't want to make that point. The implementation of the law by the government and the courts, particularly in this case, passing such an awful order against judgment after judgment of the Supreme Court in UAPA matters. 3 years, your trial has not begun, bail. 4 years, your trial has not begun, bail. The historic judgment of the present Chief Justice of India, historic judgment in Najib's case, all UAPA cases. 4 years have passed, and there's no chance that your trial will finish in the near future, bail. 10 judgments of the Supreme Court, Vernon's case, other cases, 10 judgments at least.
I want to bring in...
Now you have a judge, or now you have a bench.
Mr. Gonsalves, stay with us. I want to bring in Satya Jain back into this conversation because Satya Jain, it's been 5 years. 5 years where, charges haven't been framed, bail hasn't been given, key witnesses haven't, been examined where the Delhi police is concerned. Now, on that account, because of the various judgments and precedents that Mr. Colin Gonsalves gave, I'll give you two. You have the bench of Justices Abhay S. Okha and Augustine George Massey, who clearly stated and ruled, bail is rule, jail is an exception even if it involves a UAPA case. Then you have IB Pardiwala and Ujjwal Bhuyan observed that the right to bail of an accused cannot be withheld as a punishment irrespective of the nature of the crime, even if it is under UAPA, sir.
Madam, please understand the working of the law, criminal law, the principles of the criminal law. As I said earlier also, there is no question of any Article 14 or similarity in criminal law. Each case has to be decided on the facts and merits of each and every case. You cannot apply any hard formula to each and every bail application. The Supreme Court is the final authority as per the powers given by the Constitution of India. The two judgments that you are citing, they are also by the Supreme Court. You can't expect that every judgment will be as I want it to be. You don't want that the way you want the judgment should come. If it is not that way, then I say, no, law is not being followed, it is being flawed. The Supreme Court, I have got this 142 judgment with me, which has given all the reasons of giving bail to 5 and also reason of not giving to only 2 people. And Supreme Court has given them 1 year, that in case the trial doesn't take substantial
What will happen in that 1 year,
during
sir?
this period.
What will happen in that 1 year that hasn't happened in the last 5 years?
That I'm telling you, within 1 year, if the prosecution doesn't proceed with the trial, material witness, the court has said, you can move for bail after the protected witnesses have been examined. Because if the accused come out, sometimes there are many cases where they threaten those witnesses also. Therefore, the people are kept in jail in certain cases so that they cannot influence the witnesses.
The court has,
so
Mr. Jain, the court has said that
court,
until the witnesses have been examined, or 1 year, whichever comes in first. By the speed of the investigation, it doesn't seem that the witnesses will be cross-examined. And I'm just taking the example of what has happened in the last 5 years, sir. So what will change in the next 1 year, or will suddenly Article 21 kick in, which doesn't kick in right now?
The Supreme Court has laid down the time limit that if within 1 year no substantial progress takes place, they can apply again for bail. Supreme Court will examine that. Let's have faith in Supreme Court. We can't dictate Supreme Court that you decide in this way, because in that case you have said so, you say same thing in this case also. Supreme Court has to examine the merits of each and every case. Let's not forget Arvind Kejriwal was also granted bail. A few days back, some man was granted bail by Delhi High Court. Supreme Court stayed that. Unfortunately, when the judgment is as we are expecting it to be, we say it's very fair. And sometimes when it is not as we are expecting, so we come on many people, emergency and all that. That is not the law. We have faith. We should have faith in the Supreme Court.
So, like I said, I am no lawyer, I am a journalist, but at least one thing I have learned, and you can correct me if I'm wrong, the sheer foundation of criminal justice is the presumption of innocence. And that is the tenets which criminal justice stands on, which is the presumption of innocence, sir.
Yes, but that doesn't mean that every person who is accused of any crime will be released on bail. If you apply that principle, lakhs of people who are in jail, murder case, rape case and all those cases, everybody will be released on bail. No, the court will examine whether there is a prima facie case against you. If there is a prima facie case, as the Supreme Court says,
5 years without trial, 5 years without trial, without framing of charges. To defend that, I would think is a blot on judiciary, but then I'm just a journalist. I am no lawyer. I would want to bring in Mr. Gonsalves into this conversation. Mr. Gonsalves, this is the UAPA. This concerns anti-terror activities. It concerns sedition. These are very, very strong laws. Might be draconian, but it is the reading of the law. You're on mute again, sir.
Law has been read many times in many judgments of the Supreme Court, even in 2025, 2024, recently. So many persons have been released with 3 years in jail. So many. And the principle has been reiterated 100 times. If you can't do a speedy trial, which is in the hands of the state, you cannot keep a person in jail. And what has the court done? It has kept our finest human rights activists, I must tell you, the two who have been denied bail are one of the finest human rights activists of India, who used no violence, who only criticized the government in the strongest possible way. They are in jail for no crime except
Supreme
free
Court has,
speech.
Mr. I'm
And
really
that is
surprised.
the
Have you read the judgment?
emergency of
Supreme Court
Indira
has mentioned
Gandhi
their role.
all
Please,
over
please, you are
again.
such a senior lawyer.
This is the
Kindly read the
beginning
judgment. Supreme
of
Court
the
has
emergency of
detailed
Indira
Let's
their
go
Gandhi
one by
role
one,
in the
sir.
judgment.
all
This is
over
very
again.
unfortunate.
Okay, I appreciate.
Very unfortunate.
Okay, I'm going to end it here. I appreciate both of you for joining us. For now, both Sharjeel and Umar Khalid have been denied bail. They've been given 1 year to reapply until the witnesses are cross-examined, or it's a year, whichever comes in first. We're going to leave it at that. I want to quickly cut across to the other development that we've been tracking very closely, and that comes in from the United States of America and Venezuela. From the presidential palace to a prison transport. Maduro now finds himself in a New York court. The visuals on your screen show Maduro being escorted in cuffs to a Manhattan federal court. Venezuela's deposed leader, along with his wife, were flown from a Brooklyn jail to face U.S. drug trafficking charges, following what Washington described as a dramatic operation leading to his capture. Meanwhile, President Trump has issued a fresh warning to interim president of Venezuela, Mr. Rodriguez, saying the United States will strike again if Venezuela does not fall in line.
The next question is who's in charge of Venezuela right now? Have you spoken to the newly sworn-in president there, Rodriguez? And what are your thoughts on the entire situation? You said the U.S. would run Venezuela.
We're dealing with the people. We're dealing with the people that just got sworn in. And don't ask me who's in charge, because I'll give you an answer and it'll be very controversial.
What does that mean?
Because we're in charge. This isn't a country that's on the other side of the world. This isn't a country like we have to travel 24 hours in an airplane. This is Venezuela. It's in our area, the Don Road Doctrine.
So is that what you would say, that we're in the business of nation building?
No, we're in the business of having countries around us that are viable and successful, and where the oil is allowed to freely come out, because that's good. It gets the prices down. That's good for our country.
President, if you had to sum up Operation Absolute Resolve, would you say that it was about oil or it was about regime change?
It's about peace on earth.
How is it peace on earth?
Peace on earth. We got to have peace. It's our hemisphere. The Monroe Doctrine was very important when it was done, and other presidents, a lot of them, they lost sight of it. I didn't lose sight, but it really is, it's peace on earth.
All right, the big questions that we ask at the back of that development, which we saw take place over the course of the weekend. What is President Trump's plan for Venezuela? Is Trump planning more invasions? Is Venezuela raid all about oil? And how will China respond? Let's take these questions to KC Singh, former Indian ambassador, Dr. Taimur Baig, managing director and chief economist, DBS Bank Limited, Daniel Freed, former diplomat and Weiser Family Distinguished Fellow at the Atlantic Council. Let's cut across to Mr. Freed first. Mr. Freed, what is your reading of what transpired in the last 48 hours, sir?
We are dealing with a legally and constitutionally questionable U.S. move. Deposing Maduro, however, could find some measure of vindication if what replaces it is democracy, stability, and renewed prosperity for the Venezuelan people. That was more or less the result of the U.S. invasion of Panama in 1989. But whether U.S. policy is headed in that direction, I can't say. President Trump has spoken of the U.S. running Venezuela. Secretary Rubio has backed away from that. The United States seems to have little interest in a democratic transition to the Venezuelan opposition, which won the last election by all accounts. Instead, the U.S. seems to be counting on some sort of arrangement with the rest of the Maduro regime, which is still in power. So a great deal of uncertainty, and the U.S. is staring into a dark room, and it is not clear to me what's at the other side.
I want to bring in KC Singh as well. Ambassador Singh, when you look at the developments and India's response, to say it's very, very measured concern, but not condemnation in a fast evolving geopolitical situation, do you think it's the prudent line to take?
Look, I think there are many legal elements to it, but I think there are three basic ways, three basic reasons how you can, or justification, you can intervene and go and grab somebody from another country. One is you have the UN Security Council approval, which they don't have in this case. Second is the other country approves, which they didn't because you grabbed the president. And the third is that you say self-defense. Now, US is not talking of they're using self-defense, saying drugs were coming to us and drugs are killing people in America, and hence it is self-defense to go and get him. Now, that itself is questionable because fentanyl is really not coming from Venezuela. And then the reasons given by US, they go on varying. The Southern Command Chief, General, a lady, she said, no, it's got nothing to do with democracy. It's got to do with oil, it's got to do with minerals. So you're getting different arguments from different people. You got the European Commission, 26 countries have signed a statement. And they've said, we are not for Maduro. We think there should be an orderly transition to a popularly elected. Not do it. You can't use illegal means to do it. So there is a debate. In fact, UN Security Council is probably meeting as we discuss this. They're meeting today. And this will be brought up by China and by other countries and by Russia, the permanent members, and probably even England and France. The French have taken a position on this. And then what has happened is, I think the danger is that President Trump is feeling so emboldened by this, that he's threatening Colombia, then he's threatening Greenland, then he's back to, again, many of Cuba. So he's threatening all those. So he is saying this is the Monroe Doctrine of the 19th century, and we can intervene wherever we want. Now, what nobody has told him is the Monroe Doctrine was because the countries in Latin America had attained independence from Portugal and Spain. So the American president was saying, no, don't intervene in their independence. They were not saying, don't come to Latin America to trade. Now, that argument has been taken by President Trump. He's calling it the Monroe Doctrine. And that means that he can intervene wherever he wants. And anything which is there in Latin America, South America, Central America, they will intervene and they will grab it. And this is really something going back to colonial times, 19th century. I think it's going to lead to international debate. And particularly if he steps in on Greenland, I think it causes a serious problem between NATO and US. There would be a very wide split, which can have implications. We don't know where this is headed. Also, we don't know wherever Americans have intervened in the past. The result has not been very good, whether Afghanistan, no, it was Iraq. They were not able to bring democracy. And in this case, the final point that the ones who won the election, which is Gonzalez and the Nobel Prize winner, Machado, they've been dumped by America. Now, if you want to take, the dictator out, then call those people in and have a transition to an actually elected government, which won the last election. So all that has been sidelined. They've cut a deal with the current president, Rodriguez, and I think they're trying to see if they can get control of oil, control of the minerals, and that is what this whole game is about. I don't think there's a stable path available.
Fair point. So, Dr. Beg, less about taking a dictator out, more about the fact that Venezuela accounts for 20% of the world's oil produce, and the US military intervention was more about oil than anything else.
Well, the US oil refineries, particularly in the South, are equipped to deal with what is known as extra heavy crude that Venezuela produces. Very few countries in the world in that crude, and their refineries are not equipped to deal with that. So in a way, you could argue that this is tailor-made for oil refineries in southern United States. But mind you, none of these oil that Donald Trump covets are going to be in the pipeline anytime soon. Venezuela has a fairly dilapidated oil production infrastructure, ruined by decades of sanctions. It produces about 1 million barrels a day, which really does not make any difference in the global oil output picture, less than 1% of global output. No countries in the world that really depends heavily on Venezuelan oil, including that China. And therefore, it doesn't have major systemic implications for the oil market, for oil production, or oil price for that matter. Unless the US Congress comes up with a legal framework It'll be actually very hard for U.S. oil companies also to start devoting billions of dollars of investments in Venezuela, because what happens when around and there are believes that this entire adventure was done on the premises. So I think that there's very well reasoning, economic reasoning behind this, although it is the easy sell. It's about oil and we're going to seize it. But when we look at the fundamentals of the economy of Venezuela, it does not look like a very persuasive case.
All right. Well, the sheer fact that India also has investments in Venezuela's oil sector, do we look at this as an opportunity? We're going to come back on that question. But Daniel, Mr. Fried, I want to bring you back into this conversation. What next now? Because there's talk of Greenland, there's talk of Iran. As a former diplomat, how do you look at it? What would be the next target?
President Trump likes to keep other Americans and other countries off balance. He likes to threaten. He likes to brag. It is not clear to me that Trump is going to act quickly against any of these countries. His political base voted for him because he promised to extract the United States from foreign entanglements. Now he seems to be getting back into it. The operation to seize Maduro was frankly brilliant. It was just a textbook perfect operation, very impressive. But the outcome in Venezuela is far from clear. And it may not be as easy as Trump imagines. It's easier to conduct a quick military operation than it is to help set up a country, or as Trump says, to run a country, or as Marco Rubio says, to basically intimidate the remnants of the Maduro regime into cooperating with us. It's not clear that the U.S. has a viable or any plan for Venezuela.
Okay. All right. Ambassador K.C. Singh, to get you back into this conversation, the fact is that India has, communicated to the U.S. that if it is expected to curtail its oil purchases from Russia, it must permit other markets like Venezuela. Do you see this as an opportunity? India also has investments where Venezuela's oil sector is concerned.
I don't think Venezuela is the only source, because as has just been put, for them to go up from about just under 1 million barrels a day to a higher production level, the highest was 3 or 4 million a couple of decades ago, it's going to take a long time because they don't have the pipelines. It's a very heavy crude. It's very difficult to pull it out and then to transport it and to really develop that infrastructure. And that's assuming things remain stable within Venezuela, because don't forget the army is sulking. This was not a proper military operation. I think this was a connivance on the part of domestic forces, which allowed the president to be removed. Only most of the people killed were his personal Cuban guard. So it's a very long journey, and there are much safer places to buy oil from
than Venezuela.
Venezuela is not about to sell the oil on a discount.
Okay.
And there are many other, and the transportation costs.
Fair point. Dr. Beg, I'm running out of time, so I just want to quickly get in Dr. Beg for an intervention. How do you think China is going to react? Because not just a customer, it's also a big investor where Venezuela's oil industry is concerned.
So China is quite deeply entangled in the Venezuelan economy. You have perhaps more than 100,000 Chinese nationals who work in Venezuela. And of course, Chinese oil companies have substantial investments in Venezuela. If this is a way to push China out, it's going to be very problematic. I don't think that is part of President Trump's design, because I haven't really heard the word China mentioned in any of these discussions. It would actually be a very dangerous geopolitical escalation if that were to happen. Mind you, even in Iraq, after the U.S. went ahead with this intervention, there were fears that the Chinese investment in Iraq would be under jeopardy. Actually, that didn't happen at all. In fact, once things stabilized, China actually doubled up on it. Venezuela, in my view, would probably follow a similar script. I don't think U.S. is in there to push China out, because it's not like China has had major success in influencing a Maduro regime in any way or protecting it. the Americans went in and just abducted him just like that. So I don't think if there were any military questions, we would be discussing in this particular line of reasoning. It would be very different. So I would say that as far as China is concerned, they have to watch and see. They will also say that, if your neighborhood is that sacrosanct, what about our neighborhood? Is that then our plaything?
I appreciate all three gentlemen for joining us. Thank you. There, we're going to keep a keen eye on all developments as they take place. Thank you for watching, and we'll see you tomorrow night.